Welcome to room 592, where we unleash the truth. Tonight we have a special show for all of you. Tonight we have a very, very special show. At the top of the program, we want to have an update on what is happening and specifically with what has been transpired over the past day between yesterday and today with regards to these elections, and more specifically, the headlines of today with regards to these elections and court cases and all of that. Later on tonight, ladies and gentlemen, we'll have a look at the question, is Guyana in a state of bankruptcy? But for the immediate purposes of here and now, Mr. Anil Nandlall has agreed to join us on this show, and we are thankful that you can come on at this very late request, sir, to update us all on what is happening, and specifically with regards to the headlines that we would have seen today on the withdrawal of the contempt proceedings from the court. Mr. Nandlall, sir, welcome to room 592. Ladies and gentlemen, welcome, and without further ado, over to you, attorney at law and former Attorney General, and well, we're not going to talk about the future right now. Let's talk about today. To you, sir, Mr. Anil Nandlall.
Thank you very much, Yog, and your distinguished panelists for affording me this opportunity to be with you here this evening, and good evening also to your listeners on the radio and your viewers on Facebook. Well, Yog, you know, we are operating in a very fever-pitched, tense political atmosphere. So any event that occurs that has a political underpinning assumes peculiar significance depending upon which side of the political divide you are on, and depending upon the nature and purport of the particular event. The day began, of course, with those remarks emanating from Prime Minister Ralph Gonsalves. And that took a life of its own because they were highly political statements, and of course they were exploited for their political value. And then by midday you had the ruling from the Chief Justice in Mingo case, and that also has its own political content attached to it and excited its own political consequences. So, and these things are, you know, blown out of proportion, if one may say so, but I am here to discuss what transpired. Yog, you would recall, I don't know how many persons can recall the state of this country on March the 12th. This was the time when this country was in pandemonium. This country was in chaos. We had a ruling. Mingo had started his unlawful declarations. He was refusing to use the SOPs. Riaz Holadar, a citizen, approached a court ex parte, and what can be described and what will be described in future generations as a most historic proceedings, because it's one of the proceedings where I utilized a very unused procedural vehicle of approaching a judge orally and then giving an undertaking to file affidavits at a later stage and obtain from that judge a series of orders that prevented Mingo from destroying the future of this country. And then that matter itself, when the papers were eventually allowed to be filed, that matter itself carried certain historic hallmarks about it, because we sat, I think, on weekends to have that substantive matter heard, day in, day out, from morning till afternoon, in very adverse circumstances. And we had that matter heard. Well, Mr. Mendes came in, and we eventually won that matter with the Chief Justice giving a written judgment and granting several orders in the end. On the 11th day of March. then Mingo resumed after the orders were served. We thought that, we would have accomplished our objective because Mingo was served with the order, and we thought then that the order would have caused Mingo to, follow the law and tabulate the Region 4 results in accordance with the order and in accordance with the Representation of the People's Act. Lo and behold, Mingo blatantly refused to follow the order. And that was during the morning of the 12th. Mingo resumed the tabulation exercise and did exactly the opposite of what the Chief Justice ordered him to do. He refused to use the spreadsheet as the basis of the tabulation and continued to read from a spreadsheet. He refused to use the statements of poll, as the basis of the tabulation and continued to read from this illegal spreadsheet. And everybody was up in arms. What do? You have a court order. There are exigent circumstances. I remember distinctly 5 heads of government from the CARICOM region were here in Guyana, were meeting with the government, were meeting with the leader of the opposition. And while this is going on, Mingo continues to breach the order. What do you do in those circumstances? If not to rush and prepare contempt of court and use whatever available evidence there was to at least bring Mingo before a judge, so that the judge can have an opportunity to speak to Mingo personally and caution Mingo about his flagrant and blatant violation of the orders of the court. And it is in those circumstances that application was prepared. Many lawyers would not have been able to do that. It was done. And I don't take full credit for it. It was done by a team of persons. In fact, I did not even read the application when it was being prepared. I gave my instructions and they were prepared, and I was in meetings with the leader of the opposition and the CARICOM team. But of course, as a leader, I have to accept responsibility. And I do, because they were carrying out my instructions. And the available evidence was what we had to use. So when we when we filed that proceedings, the court fixed the very next day at 10:30 a.m. for Mingo to appear and the rest of the respondents. Now, Mingo continued his illegal tabulation from 9 to 10:30, left that Ashmin building and attended court, and was listening to the Chief Justice while the unlawful tabulation continued by his servants and their agents. And we did not even know that. The entire GCOM was in the court. Mingo himself was in the court. All of us were in the court. And it is at that occasion that the Chief Justice, to her credit, to her honest credit, went at great lengths in explaining to Mingo the nature and purport of her order, lest he was under some misapprehension. And she graphically demonstrated to him in open court, the press was there, what she meant by using the statements of poll as the basis of the tabulation. Her Honor went on to demonstrate, you must hold it up, hold the statement of poll up like this, so that the other participants in the process can see the document. If you decide to use a statement, a spreadsheet, you must explain to the observers and those participating in the process that spreadsheet was a direct extract from the SOPs, and you must make that nexus to them. In alternative to holding it up, Her Honor went on to orally explain that he can also use a projector to project the spreadsheet on a screen,
Right.
to amplify its contents so that everyone can see it.
Mm-hmm.
There was even, at one point in time, she said that whatever you use, whatever methodology you use, you are the returning officer, it is within your discretion. Whatever methodology you use, however, must involve holding the thing up, the paper up, so that the others can see. I interjected and I asked the Chief Justice to please explain to Mr. Mingo that when you say holding it up like this, it's not holding it up and pulling it down, but holding it up for sufficient time to afford the other participants a reasonable and a fair opportunity of perusing the content of those documents.
Right.
It is also at that hearing that the Chief Justice, that Justice, Madam Chairperson, indicated to the court that she is giving an undertaking that the votes will be recounted if Mingo's tabulation continues to be offensive. That is where it was born. And that hearing was held in open court, and there was not a word uttered about deficiency of materials.
Okay.
That was the evidence that was available at the time.
Mm-hmm.
Now, subsequently, after Mingo would have heard all of this explanation and exhortation from the Honorable Chief Justice, every rational mind expected that Mingo would go back to the tabulation exercise and try as far as possible to comply with the order. Mingo did even worse this time. Notwithstanding all of that, Mingo went into Ashmin's building. I followed him. So this is not hearsay. And Mingo continue to use the spreadsheet. And when I objected, I said, but you just came from the Chief Justice. And then is when he aborted the exercise and he adjourned it to 5 p.m. to GCOM headquarters, where when we went there, they barricaded the roads from High Street, from Lamaha Street, all the way to Barrack Street, and they only permitted limited personnel to go into the exercise. And that is where Mingo completed his slaughtering of the law and the Chief Justice's order. But by that time, of course, the contempt proceedings were already filed. I am not a fortune teller. I don't have foresight to know that he would continue to breach the order, to put that in the application at that time.
Okay.
And then let me just conclude. So he did that. So that there explained the circumstances under which those proceedings were filed.
Okay.
And then the chairperson on numerous occasions indicated that contempt of court proceedings was one of the bases that led to the recount. So that those proceedings were filed to get Mingo to comply.
Right.
And in my respectful view, they served their purpose. Okay. Now, of course, I intended at all material times to add to it as the evidence became available. Now, but then Riaz Holadar death came, and the other side, the respondents applied to strike out the contempt because of the death of Holadar, arguing that by some strange principle, of course they were wrong, that contempt of court proceedings do not survive the applicant, that it is some peculiar contempt of court is some peculiar type of legal proceedings, because the general rule is that a legal proceeding is not abated or defeated by the death of the plaintiff or applicant. Right. So they were
Okay.
arguing that this is some exceptional rule. Of course, they were never able to produce the law that says that, but that consumed the court time for a long period. So that
Right.
the merit of the contempt of court was put on the back burner, and we were dealing over the past few weeks with that technical issues of whether someone can be joined to continue as in every other legal proceedings when a party dies.
Okay.
And senior counsel Boston was arguing that that's a legal impossibility. And of course, he was not able to establish that. And the court eventually ruled, part of the ruling today was to add Padmini Bairo to the proceedings. Because
Okay.
clearly, when a party dies, you can add someone
Okay.
to continue the proceedings. And
Right.
then the last point I want to make, you before you come in, is that it coincidentally that those issues in the litigation culminated or terminated simultaneously with the physical recount of the ballots at the convention center. And once that process was completed, I then had available to me great volumes of evidence to establish a contempt of court a case against Mingo. And I thought that I would get leave rather than, there's a principle that you don't duplicate and have multiplicity of proceedings. So I was thinking that I will get leave to file supplementary affidavits to prove the contempt case. But my applications for leave to file supplementary affidavits were not favorably considered by the court. And that left me with the only option to withdraw the proceedings so that I can refile. Because if I allow the court to dismiss the proceedings, then an argument that can arise if I attempt to reinstitute it would that the case has been determined on its merit with a judicial determination of it, and therefore the matters are res judicata and cannot be relitigated. To avoid that legal dilemma, I took the preemptive step of withdrawing the proceedings prior to the ruling and apologize to the court and to expose myself to the sanctions of the court in relation to costs.
Right.
So I don't understand what is it that I did that is so egregious. Any prudent, sensible, tactful lawyer would have done exactly what I did. And last point I want to make, it was not that the evidence was not there, it's that the whole of the evidence to properly and comprehensively prove a case of contempt against Mingo was not before the court. Mingo, it's only like 1/10 of the cases available on the evidence. Mingo's fraud and the egregious nature of the fraud came after the proceedings were filed. But I was never allowed an opportunity to supplement my affidavits, which is not a normal thing either. But I don't want to get involved in that. So I thought I'll put that out there because I see all kinds of wild, reckless things are being published about it. But I am satisfied that my contempt of court application fulfilled the higher purpose for which it was filed, to get the recount done. And the Chief Justice, in all fairness to her, said in her remarks that I was guided by different considerations other than purely legal. And that's correct.
Okay.
Because you can't separate Mingo's litigation from its political environment.
Correct.
And I'm a politician acting as a lawyer. And I had to serve the various interests and countervail and counterbalance. And that is what I did. And if I may say so myself, I think I did it well.
Thank you. Thank you for that update, Counsel. And first question to you, and as you know, we have my co-host Leonard Gildari as well as Mr. Roll Johnson has joined us in studio tonight. So my first question to you, notwithstanding these withdrawals of the contempt proceedings, there are, as we know, other criminal charges that have been filed, cases before the court. This doesn't affect those, does it?
My friend, charging Mingo with contempt of court is like charging a mass murderer for loitering by spilling blood on the parapet. Mingo has to be dealt with in a much more substantive way. When this process is completed and the matter is properly investigated, not in a witch hunting way.
Right.
Once the investigators, that arm of the state responsible for the investigation of crime, that aspect of it will be activated at the appropriate time, and Mingo will be visited with whatever is the outcome of those investigations. This contempt of court here is the smallest aspect of the matter.
Gotcha. And so to conclude this part, the contempt proceedings have been withdrawn and there is nothing more in front of the court where that is concerned?
That's correct. But as I said, I reserve the right to refile now that I have acquired all the evidence.
You okay for me? I have an answer. I have some questions.
Yes, right.
Anil,
yes, sir.
There were other respondents in the Mingo case. I believe the 3 government commissioners.
Yeah, well, yes, and the chairperson.
Good. Would you allow that there was a misstep on the part of the people who filed on your behalf and under your direction to include them as respondents in the case without, because I believe the language used with Mingo acted under direction.
Well, Ruel, at the appropriate time, we would have put in affidavits to establish that Mingo was not acting in isolation, that Mingo was operating in the very building where all those persons were present. And persons went to them, including yours truly, and many other persons who would have put affidavits before the court, went to them to ask them to intervene in Mingo's violation of the court order, and they refused.
Yeah, you see,
you would recall an afternoon, the chairperson locked her, or somebody locked somebody in a room.
Yeah.
For hours. Kaichor News owner and Adam Harris came and tried to get into the room because we don't know whether she was locked in there or she locked herself in there. But all of that was to allow, in our view, and we would have led that kind of evidence, to facilitate Mingo continuing in his violation of the court order.
But is there a critical distinction between creating a facilitating environment and giving direction to somebody?
No, aiding and abetting.
Well,
you can do so either by your omission or you can do so by directions.
But the law says that the returning officers who's in charge of region has the ultimate responsibility for creating the environment under which a count is done. So I could see a defense being that we facilitated him to do his work with the independence that the law stipulates in determining the count.
It was not independent because they took him upstairs and locked him up in a room too.
Okay.
But I don't want to get involved in all of that.
But Daniel, hold on. But didn't Lowenfield intervene and interject himself in the process more than once?
Several times. Lowenfield, the chairperson herself, you saw those videos on Facebook. The chairperson herself, Miss Myers, Lowenfield, the commission and Mingo were interacting together. Hopefully the commission was trying to help, but the fact is that they moved the entire operation to GCOM headquarters.
What was the justification given for that? What was the justification given for moving it from Ashman's to GCOM?
Mingo said that he's uncomfortable in the environment of Ashman's. So it moved to GCOM headquarters now. So they were under their direct supervision in their own headquarters. And therein lies elements of the complicity.
Okay. Just to make a very light comment here, Ruel, Mr. Says Gunraj described that process as moving from spreadsheet to bedsheet. So,
I remember the
so counsel, just to summarize, where we are is that the contempt of court proceedings have been withdrawn, and the private cases, the private matters that are being filed, I think it's a criminal matter if I'm not wrong, that would have been filed by Ramson Jr. Towards Mingo and Vonda Lawrence. That now is in front of the court. Is the PPPC a party to that case?
No, as far as I'm aware, that was a private criminal proceedings filed. But look, everybody was in a state of pandemonium, and everyone was trying to do what they felt was good to assist and to bring reprieve or try to correct the madness that Mingo was carrying on with.
Okay.
And so you have that, but the state, these are offenses against the state. So when the state gets back to normalcy, the state will have to investigate these matters.
Okay.
And appropriate actions will have to be taken at the appropriate time. We were operating under tremendous stress and under debilitating circumstances. But we thought we had to do what we had to do, or else we would never have reached this stage here, where we had a recount of the ballots, and we are about now to hopefully get a declaration. We didn't reach here by some stroke of magic. We had to fight every hour of every day.
Thank you. So, Mr. Nandlall, thank you for that update. I have a unrelated question that I want to put to you. We have 3 minutes for the closure of this segment. But tell us about 177.
Yeah.
177 is a part of the Constitution that was introduced in 1980 when the executive presidency was created. You've gone off my screen, yes?
Yes, I'm here.
And it was crafted to protect the executive presidency in the strongest possible manner. Because Shahabuddin, Ramphal, and Forbes Burnham recognized that you can have intervening moments where one can stop by litigation the installation of a president once elected. And it is but Burnham was doing his own wickedness, so he was anticipating that kind of thing.
Right.
But you don't have those prevailing circumstances anymore.
Really?
But it's there. And it is to ensure that once the votes are tabulated and counted, and here in this unique situation, the votes were not tabulated and counted in a private room by anybody or any singular officer. These votes for these elections were recounted publicly on the airwaves of this country. That has never happened, I don't think, in any part of the Caribbean. So you had a public recount. So no one can be in doubt about the outcome, the total, and who received, which party list received the most number of votes. That is already a fact of public notoriety. It is against that reality now that one must read Article 177. And it deems Irfan Ali the president. The rest that ensues is merely ceremonial and formality. You would recall in 1997, Aubrey Norton had filed an application in which he purported to try to stop the swearing in of President Janet Jagan when Mrs. Jagan threw away the court order. Remember that famous scene or incident?
Yes.
Something that she apologized for later. But the reason, Dudnat Singh was advising her at the time he was election chairman commission. But the fact was, the legal reality was that she was already the president of Guyana, and under the constitution, she was immune from legal process. The constitution of Guyana says that the president cannot be served with any legal process. So when so the marshal of the court was wrong to have served Komrajana Jagan the papers, because she was deemed to be the president from the moment Gokul Buddhu handed Dudnat Singh that certificate of the total. Here, we don't need that because we publicly know the total. It was counted vote by vote publicly and tabulated publicly. So we know the total. So Irfan Ali is deemed to be the president. Whatever ensues there, whatever law and field has to produce, and whatever the declaration has to come, it's merely formality. It has to do now more with the allocation of seats than who is the president. Who is the president is already determined by virtue of Article 177.
I know we short on time, but let me just read something to you without comment and without prejudice, and ask you a comment on it. Article 177. This is the latter part. The presidential candidate shall be deemed to be elected as president and shall be so declared by the chairman of the Elections Commission, acting, and this is the important part, only in accordance with the advice of the chief election officer, after such advice has been tendered to the Elections Commission at the duly summoned meeting.
Yes. Yeah. Now, in an ordinary election, Ruel, you would appreciate that nobody would be counting the votes, and the votes were not counted in the way that it was nationally counted here. Yeah. So the chief elections officer would have that peculiar information, having collected them individually from the 10 administrative region. And he, after receiving that information, he can't change it. It's an automatic process. He has to simply aggregate in a report and hand it, and then he has to prepare a report in accordance with Section 96, which is of the Representation of the People's Act, which is the formula by which you calculate the amount of seats, etc. Yeah. So his report would be twofold: one, the presidency, and two, the allocation of seats for parliament. All right, because you have presidential elections and parliamentary elections, and of course the regional democratic council as well. Yeah. Now, and that is a difference. That is why it is structured the way that it is, because you need a functionary to do it. But here I am telling you that, yes, you need Mr. Lowenfield. He's the authorized officer. But the difference here is that the votes were counted publicly, nationally, and the totals are known. But of course, Lowenfield has to perform the formal act of taking that number to Madam the Commission. And the Commission must only declare that which Lowenfield carries to them. Lowenfield can't carry a different number from what was counted.
Okay.
So that's how I will comment on that.
Thank you. Thank you for that, Mr. Nandlall, and thank you for coming in tonight, sir. We do know you're very busy, and good luck with the next couple of days, as we certainly look to have President-elect Irfan Ali joining room 592 tomorrow night. But Mr. Nandlall, thank you for coming in and highlighting and updating the public with the withdrawal of the Mingo's contempt of court matter. And we certainly look forward once again to seeing you very soon in room 592, because we have some other questions that we would like to discuss with you, sir. So thank you, Mr. Nandlall, and good night to you, sir.
You're most welcome. And gentlemen, thank you very much for me interposing on your program. It was a pleasure speaking with you and being in your company. And good evening and to all your listeners and viewers. Thank you.
Thank you.